Good evening, everyone, and welcome to this episode of Affinity's Intercultural Foundations webinar series. I would like to begin by acknowledging the traditional owners of the respective lands from which we're all connecting in from tonight. I myself am on the land of the Bidjigal people, and I acknowledge their continuing ownership of this land. And I also acknowledge the traditional owners of the land upon which Affinity's office exists, the Gadigal people of the Eora Nation. We pay our respects to elders past, present and emerging, and to all descendants who have cared for this place over thousands of generations. And we also honour the Aboriginal and Torres Strait Islander peoples who are joining us tonight for this webinar. We acknowledge that this was, is and always will be Aboriginal land. My name's Dr Lewis Shetzer from the Human Rights for New South Wales campaign group. A bit over 12 months ago, we began this campaign recognising to build human rights at a local level in New South Wales. We see that a key part of promoting a society in which people are treated with dignity and respect, and to improve the quality of essential services to the most vulnerable, is to have a Human Rights Act in New South Wales, similar to what exists in the ACT, Victoria and Queensland. Such a Human Rights Act will help foster a culture of respect, fairness and dignity. Tonight's webinar marks the first public event for this campaign as we seek to build momentum to bring this to fruition. This webinar episode is in collaboration with Affinity, New South Wales Council for Civil Liberties and the Whitlam Institute, all organisations that are strong advocates for human rights and social justice. Event. If you're interested in finding out more about the Human Rights for New South Wales campaign, and sign up to receive, you can go for nsw.org. I would now like to introduce tonight's facilitator, Dr Graham Thom, who will then introduce our guest panellists. Dr Thom has been Amnesty International Australia's Refugee Coordinator since 2000. Working on human rights issues relating to refugees and asylum seekers. He has also been a board member of the New South Wales Asylum Seeker Centre for the last 10 years. He is passionate about human rights. He has worked with urban refugees and visited refugee camps and detention centres in several Pacific, Asian and Middle East countries. Welcome, Dr Thom.
Thank you, Dr Shetzer, for that warm introduction. It's an absolute pleasure to be here tonight, and I too would also like to acknowledge that we're meeting tonight on Aboriginal lands and pay my respect to all elders past, present and emerging, and any Aboriginal people who are with us here tonight. It's going to be an interesting forum tonight. 2020 marks the 75th anniversary of the United Nations, and many of us understand the importance of human rights at an international level. But what about rights and freedoms in our day-to-day life? How do we build respect for human rights at a local level and promote a culture where everyone is treated fairly and equally with dignity and respect? Tonight we will be discussing human rights at the local level, the case for a Human Rights Act in New South Wales. Our distinguished guests this evening, Ed Santow and Pauline Wright, will speak about how a Human Rights Act for New South Wales might work and how an act could benefit individuals and communities. Introducing our two distinguished speakers, Ed Santow has been Human Rights Commissioner at the Australian Human Rights Commission since August 2016. Ed's areas of expertise include human rights, public law and discrimination law. He is a visiting professorial fellow at the University of New South Wales and has a very, very illustrious bio, which is on the website, so I won't take up too much time going through his full bio. I would also like to welcome Ed. Good to see you on the screen.
Thank you, Graham.
I would also like to welcome Pauline Wright, who is President of the Law Council of Australia. She is a partner principal of PJ Donnellan & Co Solicitors on the New South Wales Central Coast and is an accredited specialist in environmental planning and development law. Pauline is a former board member of Legal Aid New South Wales and continues to serve on Legal Aid's human rights and monitoring committees. So welcome, Pauline, and welcome, Ed.
Thank you very much, Graham.
Excellent. So we have until 7:45. There's a series of questions I have that I'm keen to put to you. And we also have some guest specialists who've got some questions that I'll be throwing to. And then we'll hopefully have 10 minutes for questions from our viewers who are watching. So please feel free to flick those questions across. It would be good to get as many questions as we can. And I know we don't have a lot of time, but we'll try and get to them as best we can. So apologise if we don't get to everyone's questions. But I'd like to start with you, Pauline, if I can, because being a bit of a devil's advocate here, you know, some would argue that New South Wales doesn't need a Human Rights Act, as human rights are protected in existing legislation, albeit not in one piece of legislation. You know, if that's the case, why do we need a Human Rights Act? You know, in regards to the person on the street, you know, how will it impact their daily lives?
Look, in New South Wales, of course, there are laws that continue to encroach on the common law and human rights of individuals, including laws that criminalise association. They limit the right to protest. They encroach upon legal professional privilege, presumption of innocence, the privilege against self-incrimination, and they're really serious. And they allow, for instance, children as young as 14 to be detained for 2 weeks for questioning without charge in relation to certain offences. And the existing legislative scrutiny mechanisms fail to provide sufficiently strong safeguards against legislative encroachment. I mean, for example, there are studies about the effectiveness of the New South Wales Legislation Review Committee, and they've argued that there's an entrenched culture held by Parliament of ignoring and deflecting the committee's advice. So it's not uncommon for legislation to pass within 24 hours with no possibility of public scrutiny. And human rights protections at the state level are really important, given that states have jurisdiction over matters that can have significant adverse impact on our rights as ordinary people. Crime places of detention, including prisons and mental health institutions. They affect child protection. They affect health, education, housing, homelessness, older people's rights. And I remember that in 2014, there was a review of the ACT's Human Rights Act, and that found that it had increased awareness through government of human rights issues and provided an impetus for agencies to properly consider human rights obligations. And I think that's really important. Those are all fundamental reasons why a Human Rights Act is needed in New South Wales. And I think we have to remember that ordinary people going about their daily lives are really affected by this. One example cited from a review of the Victorian Charter's first 5 years involved a 96-year-old woman who was given a 60-day notice to vacate her home where she'd been living for 21 years. She was unable to find alternative accommodation at that time, and it was argued to VCAT that it was a breach of the Charter of Rights, and she was consequently given an additional 30 days. So there's a concrete example. These sorts of things are happening all the time. In the ACT, there's one case concerning the comprehensive updating and codifying of legislation for the protection, care and wellbeing of children and young people. Human rights issues were raised by practices like therapeutic protection orders, prenatal reporting of children at risk, searching of detained children, and behavioural management schemes proposed for a youth detention centre. And those issues were considered extensively in the development of the legislation. And it's in previously poor juvenile detention practices, which had involved the routine use of solitary confinement and strip searches, resulted. So those are really positive examples.
Yeah, no, that's really important, I think, that we are able to highlight how it impacts on individual lives. To go to the other end of the spectrum, Ed, a lot of your work is around Australia's human rights obligations under the various treaties that it's signed. How do you think a Human Rights Act or Charter in New South Wales would actually help Australia more broadly meet its international commitments to those treaties? And if you'd like just to pick up on some of the points Pauline made, how do you think it would actually impact on, say, government departments and the way they work? And also, how would it impact on specific communities like First Nations peoples or refugees or people with a disability? How do we get from that macro, again, down to that micro?
I mean, the role of governments is to take the high principles that are set out in international human rights treaties and to make them real in our domestic law. When Father Frank Brennan conducted his big national human rights consultation across Australia a bit over a decade ago, he started his report with a really important thing that he heard just from an ordinary citizen. And I'm paraphrasing here, but essentially what was said was this: if you have human rights, they're written down on a page, but there's no way that you can enforce them legally, then they're not rights at all. They're just good ideas. And I think that gets to the heart of why we need to take these good ideas that are set out in international human rights treaties that are partially incorporated into our existing law, and we need to fully incorporate those into our actual law. So that's the kind of high principle. To try and make that more concrete, I think Pauline has rightly drawn attention to how human rights acts or human rights charters are operating in reality. Another example from Victoria in the early years of the operation of the Victorian Charter was a really interesting and in some ways quite heartrending situation. It involved a group of young people, all sort of under the age of 18, who had all had very serious spinal injuries. And so they needed a very high degree of care. And the Victorian government formed a view that the simplest, most cost-effective way of caring for those people, those young people, would be to put those people into aged care facilities. Now, I can understand how, when you look at those people as just names on a page, how you might, come up with that idea. But of course, for those young people, that was a really deeply troubling and problematic environment. It wasn't therapeutic for them to be surrounded by much, much older people with whom they had very little in common. And it caused all kinds of problems in terms of their development. Now, here's the difference when you have a Human Rights Act from when you don't. If you're in a jurisdiction that doesn't have a Human Rights Act, you then have to go to the Department of Health or who is responsible, and essentially you're going as a supplicant. You're saying, please, will you help me? But that shouldn't be the relationship between the state and the people. Far better, and this is the profound thing that a Human Rights Act can do, far better that you go to the state, to the government, and say, these are my rights. As a young person, I have a right to a therapeutic environment. I have a right to be with my peers and to develop that way. Let's find a way together to get a practical solution that will enable me to do all of those things, which is also kind of a proportionate use of resources for the state. And that's precisely what happened. This wasn't a case that went all the way to the High Court or to any court. It was one where once the Human Rights Charter was invoked, it changed the dialogue between the individual citizens and the government, and it actually prompted a really practical solution that better protected those young people's basic rights.
Excellent. Well, I'm going to get a little bit controversial again on us because, while we have these charters in a number of states and territories, it's always a bit of an uphill struggle to get to that point. So I'm actually going to throw to one of our special guest questionnaires to ask his question. So this is a question from Professor Simon Rice, who's Professor of Law at the University of Sydney. So we'll see if we can get that question from Simon up for you both.
Hello, Pauline and Ed, and thank you for the presentation. If you've not addressed it already, could you share your views on this issue? There's no interest in New South Wales politics in passing a human rights law. If a party in power is to consider even the insipid dialogue model, so-called, let alone binding Parliament to human rights compliance and enabling human rights enforcement, it'll have to be persuaded that the people want it to. Can you point our politicians to contemporary calls for a human rights law at all? To any groundswell or momentum that suggests that people, not lawyers, want one? And relatedly, where do you think human rights law reform campaigners ought to be directing their efforts?
So a very, very good question, a very tough question. Actually, I might go with you, Pauline, and see how you think we can convince Simon that this is doable.
Well, look, I actually think that if it's done something good, the COVID pandemic has raised people's awareness of their rights and of the potential for their rights to be abrogated. And I've seen a definite groundswell in public opinion that is asking for protections of people's civil liberties and their human rights in this context. People are starting to ask questions. Well, how long are these restrictions on our rights going to last? What authority does the government have to make these restrictions on us? And how are we to live our lives if those emergency laws aren't withdrawn in a timely way once the real crisis has passed? So I actually do believe that there is a groundswell, and in my view, the politicians had better start listening to it, because at the moment there's a social compact. Everyone's kind of conscious that that some of those measures that do abrogate our fundamental rights are necessary because we don't want to all die from this pandemic. But if it outlasts the emergency, that's going to break down and people are going to start asking questions. So I think that the time is actually ripe for us to be pushing for this now. And there's definitely a groundswell.
Well, just following on from that then, Pauline, what kinds of guarantees then do you think a federal charter or even a state charter should include? What are some of the things that should be in there? You sort of highlighted a few in that response.
Yes, look, I don't want to give away too many secrets because the Law Council is about to release a policy paper on this, and we're going to be detailing everything that we want to do. But the starting point is that Australia has obligations to respect, protect and fulfil all of the human rights at the core of, in the core international human rights treaties. So any human rights bill federally should be including guarantees of civil, political, economic, social and cultural rights, and be primarily based on Australia's obligations under the ICCPR, the ICESCR and other principal human rights treaties to which we're a party, like the CRC, CAT, CRD, CEDAW and CRPD. The Law Council has also raised its strong support for the inclusion of the rights in the United Nations Declaration of the Rights of Indigenous Peoples, if Indigenous peoples support that inclusion. And another key feature that the Law Council would like to see is that a Human Rights Act should include explicit duties on public authorities to act compatibly with human rights. and to give consideration to human rights in the development of policy and the making of decisions. We see bureaucrats making so many decisions which affect people's lives, whether determining their access to healthcare, income support, housing, rights to a visa. And it's vital that individuals' human rights are part of that process.
Terrific. Well, I look forward to seeing what you're going to produce. That sounds excellent. It's probably worth going to another one of our guest questionnaires. This time, Scientia Professor George Williams, AO, FASSA, the Deputy Vice-Chancellor of UNSW, and Ed, somebody I'm sure you know well, good friend to us all, because we have spoken about the fact that these charters do exist already in other territories, and you've given some good examples, I think, from those states and territories. So if we've got it queued up, we might go to George's question.
Hi, it's George Williams here, and it's great to be able to ask a question of this important forum involving Ed and Pauline. My question is, what can New South Wales learn from the fact that Queensland, Victoria and the ACT have all passed human rights acts? Do you see ourselves as just copying what Queensland has done, or can we do better? What do you think would be different in the model you would like to see brought about for New South Wales?
So Ed, have you any thought to how an act in New South Wales would be the same, would be different? What lessons have we learnt? Where can we go?
It's exactly the right question to ask. What lessons have we learned? The first proposal for a Bill of Rights or Human Rights Act in Australia was in the 1890s, that was an idea for a national Bill of Rights, and we've been having this conversation off and on for the last 130 years. And so I think what we need to do is ask two questions. One, what worked in Victoria, the ACT and Queensland? And conversely, what has not worked in the other campaigns for a Human Rights Act that have led to no change so far? And maybe I'll deal with those in reverse order. I think one of the mistakes that people like I have made in the past is focusing on selling the solution, which is a Human Rights Act, without properly explaining what will solve the problem. Earlier this week, I was listening to some truly harrowing stories that my colleague June Oscar, the Aboriginal and Torres Strait Islander Social Justice Commissioner, was telling myself and my fellow commissioners about injustice, systemic, historical and ongoing injustice suffered by Australia's Aboriginal and Torres Strait Islander people. We can continue as people of good faith, good heart, to wring our hands, say how terrible this is, sort of work along the edges to make small change. Or we can say, no, we're serious about addressing these problems. And we're going to make a fundamental shift in the way in which our citizens, our people, relate to the government. What we've seen in, over decades now from Indigenous leaders in Australia is that they've said, if you want to deal with the most pressing and long-standing problems of injustice, of things as fundamental as gaps in life expectancy and so on, then you need to change the relationship between the government and Indigenous people. And so I think that's really fundamental. So I think that's something that we can learn from some of the areas where the reform hasn't come off. I think what we can learn from, Victoria, Queensland and the ACT where the reform has been successful is what are the practical changes on the ground that it makes. Pauline, I think, gave a really powerful example of just that with an elderly woman who was at risk of homelessness, the example I gave as well. There are countless examples of this. The most moving examples to me are, in a sense, the ones that are least dramatic. They're not the ones that go all the way to the High Court. They're the ones where you show how just being able to draw on the rights in a human rights charter allows a more equal negotiation between the citizen and the state. And so we've seen that in housing in particular. We've seen it in healthcare in Victoria, Queensland and the ACT. We've also seen it in policing. The ACT had what they proclaimed, the government proclaimed, to be the first human rights compliant prison in all of Australia. Now, that's not to say that that prison is perfect, and I don't think they would say that either. But what it does show is that was an area that is compliance with human rights was a goal that the government took very seriously, and that they framed the whole design of that prison and the legal kind of infrastructure that supports it around making sure that people's human rights were protected. Now, the reason I mention that is that some of the worst human rights violations that we consistently see in Australia happen in places of detention. And so if we want to be serious about addressing those problems, then we actually have to take the hard decisions that would enable that sort of change.
Yeah, absolutely. I guess one of the key questions, and I'm going to throw back to you, Pauline, is what would an enforcement mechanism look like in any future Human Rights Act or Human Rights Charter? How do you actually enforce these? How do people actually, I guess, in the examples you've provided, how do they take forward any complaint or any issue they have around their human rights? And I guess just following on from that, Pauline, recently we've seen examples where human rights are in conflict with one another, such as debates around religious freedoms. How can a Human Rights Act help governments and the community to balance competing rights?
Yep. Well, I'll go first to enforcement. There'd be a number of elements to be considered. For instance, would there be a direct and independent right of action, and what form of remedy is available? So in relation to the right of action, the Law Council considers that there should be a direct and independent right of action where a person alleges that they've been the victim of a violation of the rights guaranteed under a Human Rights Act. And this would reflect the approach taken in the ACT Human Rights Act, Section 40C. And by way of comparison, neither the Victorian Charter nor the Queensland Human Rights Act provide for a direct right of action. But if a person has a cause of action other than one that's based directly on the human rights legislation, then they might piggyback a human rights ground on that and receive relief in relation to that claim, even if the other claim is unsuccessful. So the Law Council thinks that piggybacking approach in Victoria and now Queensland is complex and confusing. So a direct right is preferable in our view. In terms of remedies, where a violation of a guaranteed right is established, then an effective remedy should be available that affords appropriate and adequate reparation for the wrong that's been suffered. So it needs to have teeth. There should be the power to order remedies that are just and appropriate in the circumstances, taking into account the kinds of remedies recognised by international human rights law as being appropriate. And that might mean compensation in appropriate cases or declaratory injunctive relief in other cases, among other remedies. In terms of competing rights, there are obviously different rights, and sometimes those can be in conflict with each other. For instance, we've seen debates around religious freedoms and freedom of expression as compared to other rights about non-discrimination or interests of children, those sorts of things. It's another area where different community sectors can sometimes raise human rights in isolation from one another. and there can be confusion about the extent to which different rights are protected. And the current legal framework under federal anti-discrimination laws, for instance, is often quite fragmented and disjointed and confusing. But most rights are not absolute and can be subjected to limitations, and should be, so that they can be balanced against each other. For example, the right to freedom of thought, conscience, religion is absolute, but the right to manifest your religious beliefs is not absolute. So when you're weighing that against other rights, such as discrimination, so if your religious practices would affect a group of people in particular, then that has to be weighed against the other right. And where you've got proper limitations on them, then that can occur and should occur. So under international human rights law, a limitation must be prescribed by law, must be necessary, reasonable and proportionate to a legitimate purpose. And that's appropriate for some sorts of rights, while others are absolute and should be absolute.
And how do you think, Ed, I mean, just following on from that, do you think a charter helps then balance that out in a way that our current legal structure clearly is having issues with? I mean, again, where have we seen examples where that's happened?
Well, part of the design of human rights law is that it is understood that rights come into tension or conflict with each other. And we all kind of know intuitively that Graham's right to swing his fist ends with my nose. Say that in acknowledgement of Graham being more of a lover than a fighter, but nevertheless, it's really important for us to find a way to make sure that it's not just one group of people's rights that trump everybody else's, that there is a proper accommodation of rights. And what has developed literally over 100 years is a set of legal principles to make sure that one right doesn't swamp another, but that you have a proper kind of balancing or accommodation of rights. And the key principles, I think, as Pauline has already cited, that rights must be balanced in a way that is proportionate, that it's reasonable, that any limitation on a particular right is necessary. And so what we've seen literally over decades now is a number of countries that already have human rights acts be able to kind of work their way through those difficult debates. And I guess a benefit of being a late adopter when it comes to human rights reform is that we can actually benefit from all of their hard work. So in really difficult things, like Pauline gave a particularly powerful example. So freedom of religion on the one hand and the right to equality or non-discrimination on the other. Now, it doesn't work for freedom of religion to be, it's not fair for freedom of religion to be completely swamped by the right to non-discrimination or vice versa. So instead, what we've seen through the kind of international human rights law process is ways where those rights come into conflict, and that's most recently happened in the marriage equality debate, to make sure that people of faith for whom that is an issue are still able to practice their faith, but that LGBTI people are not denied the basic right that applies to everyone in the community to form a family, to get married, and I think really international human rights law provides a really practical mechanism for doing just that.
Yeah, definitely. I'm going to throw Pauline another devil's advocate question to you here, just to put you on the spot. Because, are there cons, I guess, to enacting a Human Rights Act? For example, would a Human Rights Act or charter, either at a federal or state level, be costly for the taxpayers, for instance? Would would it lead to pressures on already overstretched court systems? I mean, these are some of the arguments that we've heard around, what would be some of the negative consequences. How would you address those sorts of questions?
Look, I don't think that it would necessarily cause a blowout in costs because, for a start, the reviews of the states and territories that do have human rights legislation have made it really quite clear that rather than resulting in some kind of lawyer's picnic, the key impacts of them are outside the court processes. It's in the making of laws. It's in the enforcement of laws that the impact is felt. So, it's actually more costly not to have human rights legislation in place. You look at the number of very, very costly royal commissions that we've seen into issues like aged care, responses to child sexual abuse, violence, abuse, neglect and exploitation of people with disability, protection and detention of children in the Northern Territory. I mean, these things are costing hundreds of millions of dollars. And these are very, very costly. And if we had human rights legislation, then some of those royal commissions might not have been necessary in the first place. I mean, obviously, royal commissions will always be necessary and important, but they won't be as necessary if we had a federal Human Rights Act, and indeed in New South Wales, if we had one here.
Yeah, absolutely. No, I mean, I think these are important questions that we do need to address because people who have opposed the introduction of acts and charters have often used this argument, and I think that's a brilliant way to respond. Absolutely. You did mention earlier human rights in the age of COVID and how that's playing out. So I think that's a good opportunity for us to go to our third video question. Another close personal friend of mine, Professor Mary Crock, who's Professor of Public Law at the University of Sydney. And she has, I guess, some specific questions in the age of COVID about human rights. So if we've got Mary lined up there.
My name is Professor Mary Crock. I am an accredited specialist in immigration law, but also the director of the Sydney Centre for International Law at Sydney Law School. Commissioner Santow, if I may begin with you, the challenges that prisoners face in New South Wales during COVID-19, the pandemic, what measures have been taken, how have they been affected by shutdown measures? What has been done in New South Wales and what we need to protect the homeless and to make sure that people are not left on the street. It is not in anybody's interest, of course, to have anybody without shelter and protection during a time like this.
It's a great question. I feel a little bit uncomfortable, Professor Crock calling me commissioner. Mary taught me public law when I was at Sydney Uni. Any mistakes that I made are the students, not the teachers, I hasten to say. It is a critical question. I said before that prisons and places of detention are especially vulnerable to human rights abuse, the people who are detained there. We at the Human Rights Commission are a federal body. We don't have jurisdiction over state and territory prisons, but we do over immigration detention facilities. And I think the general principle is applicable in both. And that is, in a time of crisis, like a pandemic, a true public health crisis, the risks for people in detention just cannot be overstated. We know that a virus can spread in a closed environment like a prison or an immigration detention facility very rapidly. And then because, of course, many people work in prisons and detention facilities and then go and live in the community, that can then be a vector for spreading the COVID-19 or other infectious diseases into and then through the community. So I guess what does that mean in human rights terms? It means that there's a very principled argument that people who are in detention who are particularly vulnerable need special care. At the moment, as I say, our jurisdiction is primarily immigration detention facilities. At the moment, the foremost public health experts in Australia are saying that the immigration detention facilities are too crowded, that it is impossible to practice proper physical distancing in immigration detention facilities. My understanding is that there are similar problems in a number of state and territory prisons as well. And so from a principled perspective, do we just accept that? Do we just say that people in those facilities are just going to, in a sense, cope with that much greater risk? Or do we say, no, their human rights matter because they're human, that those are immutable? And do we, as I think we should, take the extra steps that we could to make sure that people are safe? In immigration detention, that would mean taking people who don't present any significant security risk, of which there are many in immigration detention, and put them into community detention where they can be monitored very closely, but can also practice physical distancing. So there's that principled argument, but there's also a really pragmatic or practical argument. So even if that is not your main concern, the basic human rights of people in prisons, there's an overall community benefit in not leaving anyone behind. Some very interesting research that has recently come out of Singapore that basically shows that a small group of people within the Singapore community who are particularly disadvantaged, who ended up contracting COVID-19 at a much greater rate than other people in the community, that they suffered much worse for themselves, but that was also a way in for the virus into the overall Singapore community. So I guess what I'm trying to say is that there's a kind of an argument of enlightened self-interest that by protecting the basic rights of the most vulnerable people, the people that are in political terms hardest to advocate for, so for example, people in all forms of detention, you're also protecting the entire community. And that's something that we all have an interest in.
I do want to come back to you around detention and rights of people in detention, given what's happening in the Parliament at the moment with specific legislation. But Pauline, I wanted to throw to you first around this idea about no one left behind, particularly during COVID, and because this is something you raised very early on, the sort of health implications around that. Obviously, the right to health and the right to the health of the community. I mean, how would a Human Rights Act make responses fairer, do you think, and more inclusive when we are dealing with global pandemics like the current COVID pandemic?
Well, perhaps one example that might illustrate this point, it arises from evidence that was given to the Royal Commission into Disability. It was reported that a particular health bureaucrat admitted that people with disabilities were not specifically mentioned in the Australian government's COVID-19 emergency response plan, nor was there a single area in the health department that had responsibility of the health of people with a disability. And when vulnerable people were mentioned, there was no specific mention of people with disabilities. And it was noted, of course, that the action plan was prepared very quickly under great pressure, but that's a real omission, and a plan was developed later. But it's extraordinary to think that the needs of people with disability were overlooked when designing a national emergency health response to a pandemic. A lot of people with disabilities might object to being described as vulnerable. But when policymakers should be factoring in and accommodating their needs as part of their usual business, I think that if we had a Bill of Rights or a Charter of Rights in New South Wales or federally, that just wouldn't be happening. It'd be part of the thinking. The social model of disability reinforces that it's not the person's disability that's the issue. It's society's failures to accommodate them and support them and participate on an equal basis. And we saw that being missed in our response to COVID-19. I just think that amongst other advantages, a Federal Human Rights Act incorporating explicit human rights obligations for public services accompanied by appropriate training and processes would overcome those kinds of pretty appalling omissions and would ensure the needs and circumstances of all Australians are better understood and factored into that upfront policy and program design in emergencies and obviously outside emergencies too. So I think that over time it would ensure that the needs of people with disabilities are instantly recognised and reflected in a pandemic health response in a way that didn't happen this time in the absence of that kind of human rights legislation.
Yeah, no, I think that's a fantastic concrete example and clearly demonstrates how important groups, which you would think would be the most obvious groups in need at this time, are often overlooked. You know, if those safety nets aren't there, or if we don't have to be held account, or if government officials don't have to be held account to the human rights of those groups. So no, I think that is actually a brilliant example. We have some questions coming in thick and fast. I'm going to throw to you first, Ed, because a number have come through asking again, you know, how do we demonstrate the need in New South Wales for a human rights charter, and how do we build that momentum? You know, Pauline sort of gave some answers at the beginning. I'm just wondering if you have further ideas that you know, the people listening can go away with.
I think it's going to be really important to be positive and practical. There are all kinds of arguments against a Human Rights Act, and I think too often we get, those of us who support a Human Rights Act, get sidetracked by them because they're kind of so annoying. They're essentially kind of the sky is going to fall in type arguments. And we know that in Human Rights Act jurisdictions, the sky has not fallen in any of the ways that is claimed. And so, in a sense, it's kind of an affront to hear such kind of, you know, illogicality and such hogwash that we can get sidetracked in kind of debating on those negative reasons. But that doesn't give anyone who is kind of on the fence or is open to persuasion, that doesn't give people a positive reason why a Human Rights Act is necessary. So I think find some time, often perhaps in your own, maybe in the bathroom, just sort of pointing at the mirror, where you can kind of vent your frustration about those things. But in terms of the public work, I think it's got to be about framing a positive, practical argument for human rights. So showing how it will make a difference to people that you know are relatable. So different parts of our community will be motivated by different things. So I think it was particularly significant that the first example Pauline gave was a housing example. In a sense, you know, the housing is so fundamental to the way in which we live our lives. It is something that we are all, you know, in a sense vulnerable to if we don't have housing. And we all probably know people, perhaps because they're particularly old or particularly young, for whom housing is going to be a problem. even if it doesn't affect us directly ourselves. And so I think showing how this can be something that can actually make a practical difference, I think is absolutely critical. As I say, making the positive case rather than being kind of weighed down by some of the spurious negative arguments.
Yeah, excellent. We have a couple of specific questions coming through as well, and I might throw the first one to you, Pauline, around corporations and businesses. How do we keep corporations and businesses? How would a human rights charter hold them to account in a way that we're not seeing perhaps at the moment?
Look, I think we know that there's actually a lack of knowledge throughout society of human rights. There's a lack of human rights engagement and training in general, including in corporate spheres. And I think for human rights to matter in practice, they've got to be incorporated in the education and practice right across the community. And that would include in corporations, it would include in small business leaders. But a well-drafted federal human rights act would embed that general fundamental understanding across the Australian community that everybody is of equal dignity and worth. And it would provide a benchmark for the development of law. But we need, before that happens, that general awareness and education around human rights in Australia. I think we've got real issues in this country. We know that 47%, I think, in a recent survey of people in Australia said they knew not very much or nothing about human rights. And if that's the case in our corporations in Australia, what decisions are they making in relation to the products and services that they provide to Australians if they're not thinking in terms of the rights that they might be affecting when they're making their decisions and running their businesses?
Yeah.
Can I just jump in on that as well, Graham?
Yeah. Definitely.
I agree with everything Pauline just said. And as it happens, we've got one of the foremost experts in Australia on this issue, Dr. Lou Schetzer, who began this discussion tonight. Essentially, one really important way in which businesses can be brought in to the human rights conversation via a Human Rights Act is the provision in, for example, Victoria and the UK and elsewhere. It says if it's a company that is delivering what is essentially a government service, then it must comply with the Human Rights Act. And that's very important because, as we've seen now over decades, governments of both political persuasions have increasingly delivered services, performed key functions, not necessarily wholly themselves, but through outsourcing and other similar arrangements. And so what a Human Rights Act can do in a very practical and effective way is to make sure that when that outsourcing, for example, takes place, that people's basic human rights are still protected. And so that's, I think, an important way in which we can kind of maintain a sense of important accountability and rule of law, even when we see that shifting of government services outside of government.
Including prisons and detention centres, of course.
Yeah, absolutely.
That's a really good example.
I think we've got a minute left, and I guess one of the important questions I think that's come through, specifically around New South Wales, how would a Human Rights Act or Charter protect Indigenous people in New South Wales specifically? How has it been used in other states, and how would you see it in New South Wales, protecting the rights of Indigenous people? Pauline, maybe first, and then Ed. Sorry, we're in our last minute, but I think it's a crucial question.
Yeah, look, it is a crucial question. We need to be, without a Human Rights Act in New South Wales, it means that we're not focusing on the individual rights of Indigenous people and the way that they are affected by the laws that we pass for others. Sometimes our laws can have the effect of discrimination against groups of people, such as Indigenous people, without intending to. We see all the time the disproportionate impact of bail laws on Indigenous people. And if there was a proper measure of laws as they're brought in against human rights standards, that wouldn't be happening. That's been one of the recommendations of the Deaths in Custody Royal Commission. All sorts of reports have said that these things are essential. Mandatory minimum sentencing, for instance, in the Northern Territory, saw massive numbers of Indigenous people being incarcerated without that being the intention of the law, but because it affected Aboriginal and Torres Strait Islander people differently to the rest of the community and in fact discriminated against them, that's what we saw happening. So these are ways that that human rights legislation can help and should be directed to. I'm sure Ed has something to add to that.
Yeah.
When we talk about a Human Rights Act, we tend to focus disproportionately on civil and political, but as was noted right at the start, economic, social and cultural rights are also very important. So to give what is genuinely intended to be a hypothetical, or mostly a hypothetical example, imagine if a mining company were considering essentially desecrating an ancient Aboriginal site of great importance, cultural importance. What a Human Rights Act that actually incorporates those particularly cultural rights would do is that it would provide the local Aboriginal or Torres Strait Islander community with a legal basis under Australian law to say, no, you can't just go and do that. So I think that there's real importance in considering also those economic, social and cultural rights, as well as the civil and political rights that are kind of more kind of common in our public conversation.
Yeah, that's a great example. I don't know where you would get that hypothetical example from, Ed, but that was a very clever one to come up with. But no, that is fantastic, and I think everyone has learnt a lot from both Pauline and Ed tonight, and I would personally like to thank you both for your time. That has been incredibly insightful, incredibly interesting, and I can't wait to work with you both going forward on making this a reality. It's something that I certainly hold close to my heart, and I'm certainly heartened to see such amazing people on board and leading the fight for bringing about a human rights charter in this state. I'd like to quickly call upon the director of the Whitlam Institute, Leanne Smith, to present the concluding remarks.
Good evening, everyone. Pauline, Ed, Graham, thank you so much for such a wide-ranging conversation that really drew out through your own comments and also through the questions that came through why a Human Rights Act would be so valuable in terms of promoting a culture of respect for all people and also holding decision makers to account for the human rights implications of the decisions that they make. This was just a fantastic expression of the practical ways the Human Rights Act could help. I'm not sure if all of our viewers or listeners this evening would even be aware that Australia is the only developed Western democracy in the world without a Bill of Rights. I think it's something that a lot of Australians would be shocked by, to realise that that's where we fit in the scheme of things. And this conversation is so heartwarming for me as well as it obviously is for Graham too, because 23 years ago I wrote a legal thesis about why a federal constitutionally entrenched Bill of Rights would be a good thing for Australia, and compared what was happening in another jurisdiction in Canada where they do have a constitutionally entrenched Bill of Rights and how that protected Canadians as citizens of that country. So in some ways I'm a bit disappointed to see that many years later it feels like the support for a national constitutionally entrenched Bill of Rights is not as strong even as it was 23 years ago. As somebody who has spent a lot of time overseas coming back to Australia, I have the disappointing impression that the language of human rights has been lost in lots of ways in Australia. If you go outside of legal circles, if you go outside of the human rights advocacy circles, in general conversations among the population and in different communities, human rights has almost become a dirty word in some ways. And I think that part of what we're trying to do through this Alliance for a Human Rights Act for New South Wales is to use the language of human rights in a positive way, as Ed said, and to bring it back into the conversation, rather than having people who are doing great human rights work choose other ways to describe what they're doing, so they might get more funding, or so that their work might be better valued or respected. Last year, the Human Rights Commission had the Human Rights Commissioner, the UN Human Rights Commissioner, Michelle Bachelet, out here in Australia, and the Whitlam Institute was lucky enough to have her deliver the Whitlam oration. And despite the fact that I had this impression that human rights was not very interesting to most ordinary people, we had over 800 people show up to hear her speak. And so many people came up afterwards and just said, this is like oxygen. This is fantastic. Why don't we hear more of this? So there's a real appetite. I agree with Pauline. There's a real appetite for talking about human rights in this society. So if you are one of the people sitting there listening tonight who are excited by what you've heard and you want to get involved, or if you just want to give feedback about way the argument for a Human Rights Act is being cast, or indeed if you want to challenge the argument and give some feedback about why you think it's not a good idea, then please get in touch, because as Simon Rice's question really pointed out to us, if we don't start the conversation at every level and across all communities, then this is not going to become a reality in New South Wales, because we have to have people talking about it, challenging it, understanding the issues before we're going to get anywhere. So the website is humanrightsfornewsouthwales.org, all lowercase, all one word, humanrightsfornewsouthwales.org. And if you head over there, you can find some fantastic resources, including some advocacy and a new advocacy guide that's been put together. So you can host an event, you can keep the conversation going with your family and friends, and we'd really love to have you join us in trying to work for human rights for all, at least in this state, if not across the country at this stage. I know that Ahmet is about to give some thanks to everyone, but before he thanks everyone else, let me, on behalf of the panel and everyone in the audience, give a big thank you to Cousin Ahmet Polat and to Affinity Intercultural Foundation for co-hosting this event tonight. It's been fantastically produced, and we're very grateful for the platform.
Terrific. Thank you, Leanne. And yes, huge thanks to Ahmet. But before passing the microphone to Ahmet, Executive Director of Affinity Cultural Foundation, I'd like to announce New South Wales Council for Civil Liberties upcoming event. The New South Wales Council for Civil Liberties will be holding their annual fundraiser, First Nations Justice, Civil Liberties and Indigenous Australians, on the 11th of September at 6:30 p.m, with speakers Judge Matthew Myers AM, Telia Reid, Sarah Hopkins, Nicholas Cowdery AO QC, and moderator Richard Ackland AM. So keep an eye out for that one. So to end the night, though, I'd like to call on Ahmet Polat to present the final thanks. But again, thank you to our speakers, and thank you, Ahmet.
Thank you, my new cousin Graham. Tonight has been another successful event. Great speakers, great topic, and great questions. Affinity has been honored to host a vast array of speakers in collaboration with distinguished institutions, New South Wales Council for Civil Liberties and Whitlam Institute. A special thanks to my cousins Leanne and Amanda, ALHR President Carrie, and of course all my other cousins running behind the event tonight. Together we are uniting for the rights and freedom for all. What is important is to have an integral vision, ecosystems of universal values of humanism. We are all human beings and need to promote universal human values based on human rights and the rule of law. We must reaffirm our commitment to the dignity of all humans and to our values of peace, mutual understanding, and respect. Like tonight, Affinity has been hosting many events over the past and is continuing to bring a new webinar episode each week this year. Next Tuesday, it's 8 September, Affinity and UNHRC will be hosting the webinar, Stay and Deliver, how UNHCR is meeting the challenges of displacement in 2020. UNHCR's National Director, Naomi Steer, and Ambassador for UNHCR Australia, Peter Gold, will be in conversation with my cousin, Craig Foster. For more information, please refer to Affinity's webpage or subscribe to our YouTube for future events. Thank you all and have a good evening. Thank you.